Yes, thank you. You may be seated. I think, Advocate Lowe, before you start, my colleague wants to ask a few questions or clear up certain things.
Thank you, Mr. Commissioner.
No, I just think we should go through the first part and all that, and then the second part, I will ask a few questions. Yeah.
Thank you.
Good.
Thank
Carry
you.
on, Advocate Lowe.
Mrs. Mori, can we then start off by asking you, you came here voluntary?
Yes.
It was not necessary to subpoena you?
No, it was not necessary.
And the statement that you have presented to the Commission is your statement drafted by yourself?
Yes.
Were you assisted by lawyers?
Yes.
Right, thank you.
Can I comment?
Now,
And have you gone through it afterwards,
Yes,
before
I
you
have.
signed it?
Yes, I have.
There is
Commissioner.
nothing that anybody else inserted?
No.
Good.
is it, before I start with your statement, there are certain preliminaries that I'd like to get out of the way. Is it correct that you have on numerous occasions requested my assistance and that of my team to assist you to get documentation to prepare your statement?
So, just to clarify, so I did request Advocate Lover to assist me with certain documentation so that I can get access with it, but further to that, the PIC did allow me to have access, supervised access.
Thank you. And we have responded to your request timely.
Yes, they have.
Have my team and myself treated you at all times with dignity and respect?
I think my most interaction was with you. I've never interacted with the investigation team, so you have assisted me.
Thank you. Now, before we start with your statement, there is another aspect I'd like to get out of the way. On the 19th of June this year, on the front page of the Star newspaper, there appeared an article referring to a leaked letter written by you, and that letter has revealed how the evidence leader, and that is me, had instructed you and the rest of the board of the PIC, senior management and staff at the asset manager, to provide detailed information specifically related to just 9 group of companies. The emphasis is on the word instructed you and the board. Now, I've requested you to bring that letter to the Commission. Have you got a copy of that?
Yes, I've got the letter, but can I just clarify? Through you, Commissioner, thank you very much. So I think in addressing this point, I will not directly deal with what the media is saying. I'll directly deal with what transpired, because I'm not privy of the letter that was leaked. I'm only privy to the letter that I did write to the board, updating them about the progress regarding the commission.
Now, if you will have a look at the letter dated the 15th of January 2019, and it's directed to the Board of Directors, I've asked the Secretariat to place copies before the Commission. Do you have copies, Mr. Commissioner?
No.
Do you have copies?
We have copies. Can we place that? It's fine. Can you just...
I don't know where we are in terms of exhibits, but should we rather follow the annexures to the statement?
That's my intention, Mr. Commissioner, to make that a further attachment or annexure to the statement. And I'll give it a number as the witness finished. Can I just, and it's important for this commission, because this article in the Star newspaper is also an attack on this commission. Can you just please read into the record the letter dated 15th of January addressed to the Board of Directors?
Through you, Commissioner, can I maybe in answering that start off with the background? It's leading to that letter. So it will also help you with the annexures, the way they're sitting in the pack that I've just given you. So on the 18th of December, Advocate Liver sent an email to Dion Botha. So it's the first page, it's an email on the first page, highlighting certain information he needs. So if I read the letter, it says, "Dear Mr. Botha, I urgently request information regarding the following investments. Number 1, IO Technologies. Number 2, INMSA. Number 3, MST. Number 4, Sagabatha. Number 5, Lancaster. Number 6, SNS Refineries. Number 7, Tosako. Number 8, VBS. Can you also include the MOI of the PIC? Can you urgently provide a copy of the separation agreement with the previous IT head?" So this was an email which was forwarded to EXCO by Mr. Dion Botha. He forwarded to EXCO on the 18th, highlighting to them the investment that Advocate Lava had requested. Then if you go to the next annexure, on the 8th of January 2019, Mr. Laba wrote myself as the then acting CEO a letter, heading saying, "Afternoon, the list as promised," because we had a meeting where I said, "Can I please have a list of the investments that you would like to see?" So the letter reads, "Afternoon, the list as promised. IoTech, INMSA, Lancaster, MST, Sagamatha, SNS Refineries, Tosako, VBS, Steinhoff, Grit, Ascenders." I responded to this email from Advocate Lava and highlighted to say, "Thank you for your email. Quick question. I see even this list does not have NEF and also ESCOM. Should I take it that they are not applicable?" I won't go further for that. Then Mr. Advocate Lava responds and says the two mentioned must be included. Given that the Commission had started commencing, I felt duty bound that to start informing the Board of what has transpired, because there had not been too much interactions with the Commission. So on the 15th of January 2019, I wrote a letter to the Board updating them about what is happening in terms of the inquiry. I don't know, through Commissioner, do you want me to read everything in the letter?
Please do.
Okay, thank you. The letter is headed, "Further update, Commission of Inquiry into allegations of impropriety regarding the Public Investment Corporation, SOC Limited." The purpose of this memorandum is to apprise the Board of the latest developments with regards to the Commission of Inquiry into allegations of impropriety regarding the Public Investment Corporation, SOC Limited, PIC Commission. Background, 2.1.
Thanks. You can skip
that.
2.1 and 2.2.
Okay, 2.4 says, Advocate Laba sent an email on the 18th of December requesting documentation, mainly focusing on investments that were in the news during the past year, as per the terms of reference of the Commission. He requested all documentation pertaining to the following. I list the information that he had requested on the 18th of December. 2.5, I then highlight Advocate Laba has requested on the 8th of January 2019, after meeting with the acting CEO, the following additional documentation. I list the additional companies which he had requested. Do you want me to continue? Advocate Laba has recommended that the PIC appoint a senior counsel who is familiar with Commission of Inquiry to assist board members, management, and staff who have been required to testify at the Commission with preparations. The PIC will do this through a deviation of its procurement process for legal services due to the urgency and sensitivity of the matter. Advocate Laba and the forensic investigator, Mr. Dinas Reda, met with the acting CEO and the acting company secretary on the 9th of January 2019, informing them that the investigation will start on the 14th of January 2019. It is envisioned that the inquiry will start on Monday, the 21st of January 2019. The venue for the inquiry and whether it will be televised are still to be confirmed. The plan is for the inquiry to happen on the following days. So highlight the following days being phase 1 and phase 2.
Thank you. We can stop there. That's the relevant part of the letter that I wanted you to read into the record. Do you see or find anything in the letter that I instructed you or the board to do something?
So the word instruct, so you just requested information on an urgent basis.
Now, the Commission responded to this.
Sorry, Advocate Lubbe, sorry to interrupt you on that. I think that in terms of the response by Ms. Moray, it's important to also just record that the requests were, in her own words, in keeping with the terms of reference of the Commission. Correct?
So I highlighted in 2.4.
Yes, as you said. So therefore, these are not requests that came out of, unrelated to what the work of the Commission was. And I think the second thing that perhaps just for completeness, Advocate Lubbe, I would suggest 210 be read into the record as well in the letter, add paragraph 210 of the letter.
Thank you, Mr. Commissioner.
Okay. 210 states the following. Advocate Lubbe also requested the following information, which was provided. Copies of all PIC policies, list attached as Annexure B, copies of all relevant legislation as per the quarterly regulatory universe submission to the board, PIC organogram, names of PIC employees and office contact details, list and contact details of termination of employment between December 2014 and December 2018, list and contact details of PIC clients.
And if I could ask you, Ms. Mora, whether you found any of these requests inappropriate or unrelated to the work of the Commission?
No, Commissioner.
And I'm assuming that the board likewise had no misgivings about the requests?
I would take it they didn't have, sir.
What is important further, in this letter, paragraph 2.6, you advised the board that I recommended the PIC to appoint a senior counsel familiar with commissions of inquiry to assist the board members and staff.
Yes. Yes, through Commissioner.
And as a result of that, the firm of attorneys Poswa Incorporated was appointed.
Yes, Commissioner.
And Mr. Terry Motau, senior counsel, was appointed.
Yes, yes, Commissioner.
And I was then requested from the date of their appointment, when I need anything from the Commission, or if I want to inform the PIC of anything regarding the Commission, to work through the firm of attorneys. Is that correct?
Yes, Commissioner, is my understanding.
The Commission responded to this statement in a media statement dated the 20th of June, which is a response to this letter. I'm not going to read it, but what is important is on the 20th of June, again in the Star newspaper, there is now mention made that independent media in a statement on Thursday expressed shock at the inference and what is considered to be attack by the Commission as an attack on press freedom in South Africa. The story was based on indisputable facts contained in a letter written to executives and the board of the PIC by former acting CEO Matsepe More. The existence of the letter has been verified, and independent media will, if necessary, release it to the public in order to substantiate the facts, said independent media. Now, can I just ask you, apart from the letter that you have read into the record, do you have any other letters, or do you know of any other letters written by you instructing you or the board to do anything?
So as far as I'm aware, through Commissioner, that's the letter I wrote, but as I highlighted to you, I have limited access to my emails, so I went to find a letter which I could have just assumed that's what the letter that was leaked was based on. But as far as I'm aware, in my personal capacity, and I had limited involvement with the commission, is that that's the letter I wrote.
And there's no other letter that you wrote except this one?
No, I'm not aware of any other letter that I wrote, Commissioner.
To conclude with this topic then, I have in my possession now that the media people handed to me this morning. It is a statement by independent media. It's a media release. It is dated the 29th of June 2019. I think it's something in the future that's got to happen soon. But anyway, it says, media release, freedom of the press is under threat if facts cannot be published. Independent media published a lead story on 19 June 2019 in which it clearly demonstrated the prejudice, and that's the the prejudice of the PIC Commission of Inquiry towards black-owned companies, especially from the Sekunjalo Group. The story, written by senior journalist Ayanda Mdluli, Sizwe Dlamini, and Noni Mokati, was based on indisputable facts contained in a letter written to executives and the board of the PIC by former acting CEO Matsepe Mori. The existence of the letter has been verified, and independent media will, if necessary, release to the public in order to substantiate the facts. In a media statement, response to allegations made against the Commission and its evidence leader dated 20 June, the PIC inferred that independent media is indulging in a Bell Pottinger-like disinformation and propaganda campaign. Now, again, it's factually incorrect, but be that as it may, that's just what it reads like. We condemn with contempt independent media is familiar with the code of conduct and ethics governing the press in South Africa and adhere to it. As such, it considered the evidence before it and published what it considers to be a factually correct news story. Independent media is therefore shocked by the inference and what it considers to be an attack by the Commission of Inquiry into alleged impropriety at the Public Investment Corporation as an attack on press freedom in South Africa. Independent media stands by its journalists. Mr. Commissioner, have this been handed up to the Commission?
It hasn't been handed up to add to the record, but we do have copies. We saw copies of the statement.
Thank you. I will ensure that copies are handed up to the Commission. What is important is that in this statement, it makes mention that it is clearly demonstrate the prejudice of the Commission of Inquiry towards the black-owned companies, especially from the Sekunjalo Group. And if we have a look at the list that I've sent initially to the PIC and the board, I see only 2 companies related to the Sekunjalo Group being AO and INMSA. Is that correct?
Sagamath is 3.
Sorry, Sagamatha, 3. Is that correct?
Yes, and it's being number 1, number 2, and number 4.
And later to that list is in fact added Steinhoff and Ascendus, Grit, NEF, and ESCO.
Confirmed? 3, Commissioner, correct?
Sorry, if I can now start, unless there's any questions on this topic by the Commission, Mr. Commissioner, I'm going to carry on to start with the statement now.
No, just to add that, I mean, you have added other companies which were alleged not to be there, you know.
Absolutely correct, Mr. Commissioner. In fact, at the moment, we're standing at 38 companies.
And nowhere in the letter do you say anything about being instructed to do anything.
3, Commissioner, no.
And my instructions and information is, Mr. Commissioner, these journalists who wrote this article in the Star They were present in this commission all along, and they sit in this commission. And the statements of witnesses testifying about these other investments are on the website of this commission. I will then start.
Let's first give the document annexure number.
Thank you.
62, isn't it?
Can we make these 62A and 62B and C?
What's A and what's B?
A is then the
The emails, yeah.
the email,
Yes.
then the letter dated 15 January, and then the independent 29 June 2019 statement.
62B.
That's got to be C.
C, okay. What is B? Oh, B is the letter, okay.
15 January.
Can I help you? So 61A should be the letter of the 18th of December. 61B should be the 61A should be the email of 18th of December.
Okay.
61B should be the email of 8th of December. 61C should be the letter to the board.
And D should be then be the statement. Thank you, Ms. Morey.
I think it's 62 then 61. You've got an annexure 61 here.
No, it ends at 60.
61.
61. Okay. So it should be
Let's start all
62.
over again. The email,
So the email of the 18th of December shall be 62A.
hey,
The
that's right.
email of the 8th of January shall be 62B. The letter, the updating the board shall be 62C.
62B.
And the independent media statement that you read out, that
62D.
you refer to now, should be 62.
D.
Okay. Yes, thank you.
Thank you. You can then please start with your statement on page 3, paragraph 1.
I, the undersigned Matapo More, state the following. I'm an adult female employed by the Public Investment Corporation as its Chief Financial Officer. I was contacted by the Chief Evidence Leader of the Commission, Advocate Laba, on the 1st of May 2019, who requested that I provide a statement and appear before the Commission to deal with certain matters set out in its terms of reference. Following a discussion I had with the aforementioned evidence leader regarding the exact scope of the matters I would be required to address, we agreed that my statement should cover the following issues.
Right, sorry to interrupt you there.
And if you can, Ms. Morey, do it a little slower than that.
I'm just not with you. In fact, I started corresponding with you before the 1st of May 2019 regarding appearing before the Commission and preparing a statement.
So just to clarify, so specifically why I've referred to the 1st of May, it's the 1st of May where we started discussion of the topics that we'll be discussing today.
Paragraph 1.3.1, was that agreed?
So in the email that I sent you, I think last week, I highlighted, because one of the key things that came out from this commission was victimization. And the victimization came from, on the 13th of March, there was victimization that Mr. Alvin Shield appeared before the commission and highlighted that I've been calling people to appear before this, and they call it the 7th floor, which is another form of victimization. So I was highlighting the victimization, and I singled that one out because for me it was also critical.
Thank you. Can you please proceed?
Okay. So, okay, so from 1.3.1, allegation and/or insinuations of interference with the work of the Commission, allegation and/or insinuations of victimizations made against me specifically in relation to matters relating to James Nogu's investigation, performance-related matters, and other forms of victimization, remuneration and incentives within the PIC, the role I played in the IO transaction, and the allegation regarding fruitless and wasteful expenditure relating to the office move to mainland Maine.
Just to make it clear, it was never agreed in my view, that this is a closed list. In fact, I have warned you that I cannot give you a closed list because I can't tell you what the Commission will ask you. Is that correct?
It's correct, Commissioner. Can I continue? At the outset, I wish to point out that it is not my intention to deal with each and every allegation made by other employees of the PIC in relation to the above matters in this statement, but to confine myself to certain pertinent issues raised by witnesses before the Commission and/or by the evidence leader. Should the Commission require that I address specific issues not dealt with in the statement, I will prepare another statement in relation thereto. I further wish to state upfront that I confine myself to allegations that were made against or directly impact on me in my capacity as the CFO and elsewhere acting CEO.
Ms. More, just a question from me, please. In terms of 1.4, you said you choose to answer some questions and all that. How did you go about deciding which allegations to answer and which not to answer?
So specifically relating to a lot of allegations that comes to the victimization of staff, one of the key things I did was look at the testimony and the statement of Mr. Chris Polwani, because he tended to address a lot of those issues. You will see when I get onto the victimizations part of my statement, specifically in the employee relations part, I specifically state that I do believe that he had sufficiently addressed, but areas which I believe that I needed to re-emphasize, I emphasize, or areas which I believe when reading his transcript were not clearly articulated, I then articulate them again. It also includes in the remuneration and incentives.
Okay, all right, thank you.
1.6. The facts contained herein are, save where otherwise stated, within my personal knowledge, and are to the best of my knowledge and belief both true and correct. Before I deal with these issues, I outline my qualification and experience. Section 2. In 2003, I completed a Bachelor's of Business Science Finance degree at the University of Cape Town. I then completed a Bachelor's of Commerce in Accounting Honours, which is CTA, at the University of Natal in 2004. I started my articles at Deloitte in 2005. I completed my articles and was signed off as a qualified chartered accountant at the end of 2007. Post my articles, I was seconded to the Deloitte New York office in order to obtain international exposure. During the secondment, my main client was Blackstone, a leading global alternative asset manager. Upon my return to South Africa during 2008, I was appointed to the position of audit manager at Deloitte. Slow down, sorry, I'll try my best. Okay. On 1 March 2009, I was appointed at the PIC as financial manager. From December 2009 to April 2010, I was appointed as the acting CFO.
Can I just ask, on the first appointment at PIC, in what department or division was that?
So financial manager is I reported directly to the CFO, so it's the position below the CFO of the PIC then. On 15 November 2011, I was appointed the CFO, reporting directly to the CEO.
Thank you. Again, can I interfere or stop there? Sorry. This appointment, was the position advertised? Were there interviews? Can you just explain that to the Commission?
Yes, the position was advertised. There were interviews that took place, so I was a successful candidate. Okay, continue. From June 2014 to December 2014, I was the acting CEO. After the completion of my acting stint, I returned to my position as CFO, which role I continue to occupy as at the time of the statement. Coming to section 3.
Before we do, Ms. More, if I could ask you perhaps just to outline how you see your role. How would you see your role, how the role you play as a CFO in relation to the PIC?
Can I maybe ask you to elaborate a bit more, ma'am?
Well, what do you actually do? I mean, in some of your testimony, you say you're just there to sign off on payment. The CFO role, as it is, both when you started and now, how has that role changed? Has it changed at all? What actually do? You sit on the ExCo. Do you approve things? Do you sit on committees? If so, which committees do you sit on? Do you sit on investee boards? If so, which boards? Do you see anything in that? I would like just to understand how you see your daily function and what roles and positions you occupy.
Thank you. So I'll just start, okay, and today, so maybe to go, which committees I sit on. So I'm a member of the PMC, which is the Portfolio Management Committee, both for the listed and the unlisted and the property. I am a member, let's go back. So there's 2 executive directors of the PIC. So I'm one of the executive directors.
Just explain that a little bit. The executive directors, there's only 2 executive directors, which is yourself and?
The CEO.
And how did that come about? Because your MOI does not limit it to 2.
Okay.
So when the MOI, the leadership changed in the MOI, other positions were done away with. What was your view on that?
Okay. In answering that question, I'll do background. So in 2015, we embarked on a structural review. So one of the key things we looked at certain companies that are similar to us, so the likes of Coronation, Old Mutual. We looked at DFIs, even though we're not a DFI. We looked at NEF, we looked at ITC. In looking at the structure, we found, you'll have to always remind me. In looking at the structure, what we identified was that in all of these, 2 positions were executive director, being the position of the CEO and the position of the CFO. Then further, what we did, we looked at, if you look at things like IDC, we even looked at the Canadian Pension Fund Plan. If you looked at it, is that we looked at the PIC being a broad institution and that we have to look across to say what happens. So let me explain. If you look at the likes of IDC, NEF, they don't have a CIO in the name CIO. What they have, it would be executive heads, and they use sectors or asset classes which they are basically invested in. If you look at like the Canadian Pension Fund Plan, which is in Canada, one of the biggest, you'll see that they spread also into asset classes, and because they've also got geographical spread, they'll also spread it within the geographical to get the view. We then identify that if you really look at the PIC, it's made up of big asset classes, and when you compare it to the market, it's small little institutions. Therefore, we spread the position of the CIO to be the executive head of listed, executive head of developmental investing, now called impact investing, executive head of properties, executive head of, I need to name them. It's listed properties, Isibaya, so Isibaya and private equity. One of the key things we also looked into in putting together the structure was the fact that we needed a research. It didn't make sense that we didn't have a head of research. We created the position of the executive head of research.
Sorry, can I interrupt? You talk about we. Who are the we that were involved in this restructuring process?
So it's management, so we started, let's go, we had the HR was there, the then CEO was there, and then this is the information we then took and we presented to the Human Resource Committee, then further took it to the board. And then one of the key things we looked at, and if you look at our competitors, a lot of them have, the biggest assets we have is HR, it's our human capital, we're an asset manager. So there's 2 biggest resources, it's human capital and the IT system. And then there was the creation of the executive head of HR. Then we looked at the key post-investment monitoring. By that time, we created a general manager of investment monitoring. One of the key things looked at was that to ensure succession plan, especially in terms of the CFO position, the position of the general manager of finance was identified. One of the key weaknesses when we put in the structure together, we had identified was that the AUM finance was actually not reporting to the CFO, it was reporting to the executive head of corporate service, which put a potential problem that the accountability of accounting was not sitting inside the CFO's domain. So that's when we moved the department which we refer to as investment administration inside the finance team, reporting to the general manager indirectly to the CEO. That's actually AUM. That's the finance section of AUM. some of the critical things we identified were like, some of the critical things we identified is that we need legal. We need legal at a specialized level, at a high level in the structure. Therefore, we created the position of the executive head. And then we had a CRO, a CTO, and a COO. So we did a review of the structure, and in that structure, the CTO position was actually enhanced. There were new positions, so the org structure increased. We started breaking down that into security in terms of system and database and infrastructure. So that team, we also included inside that team the governance team in terms of IT. So the role of the CTO expanded. Then we had the CRO, so the CRO being the Chief Risk Officer. We also expanded that role. We started creating compliance, investment risk, and operational risk. So putting together the whole risk area into one. We took the structure to the HRRC, which is a Human Resource Committee, which was then approved and recommended for the board. We then took it to the board for approval. So the board approved the new org structure, taking into consideration the research that we had done to show that how our fellow competitors are actually comparing in terms of the structure. And then when we tried to change the MOI, the then minister, so the minister that was there signed off the change in the MOI. The minister that subsequently came requested that we refrain from changing the MOI. So hence why the MOI is not a reflection of the current structure.
Can you just please put names to the ministers?
Okay. The then minister that approved that we changed the MOI to align to the org structure was Minister Praveen Gordon. The minister who then requested that we do not change the MOI was Minister Malusi Gigaba. So it's in that. So now elaborating further on my role. So I'm a member.
Sorry. No. The question for me relates to, you then have, as I understand your structure, and we've seen in the evidence before us, you've got your executive heads, but you have two centers of power, the CEO and the CFO. That has come through completely, that this is what determines the evidence that has come through all the time, is that the role of the CEO and the CFO, that without you in meetings or in committees, the committees do not happen. Is that correct? And again, I would like to come back to the list of all the committees that you sit on as the CFO.
So through Commissioner, the centers of power, we will not single-handedly approve things by ourselves. So I disagree with that conclusion that it's the centers of power. It's just the two executive directors. So let's go. So
Wait, let me just understand that you're saying because there are two executive directors, it's not centers of power.
So maybe elaborate what's the definition of centers of power, because
the decisions ultimately get taken, because if you've got a specific role, the CEO has a specific role, the executive functions in a particular way, but a CEO has overarching roles. There's a role for a CEO that's different from an executive head of a department.
Maybe I'll use the PFMA. The CEO is the accounting officer. So ultimately, if you look at the PFMA, he is the person. So let's go back to the centers of power, and I'll use demonstrations of committees. So no committee was it, and specifically the management committee, no committee could make a decision that stipulated that either myself or the CEO had a veto ticket. So we had no veto to say, if we say no, no transaction happens. Prior to the change in the terms of reference, it was that one of us had to be present, just present, not that we have to be, actually it's our say, that's the final say, no. If you look at the terms of reference of every committee, a decision shall be reached by consensus. So we did not have the veto ticket. If you look at the risk report and I'll call them the assurance provider report, all of them are actually, the last person who signs off is the executive head. None of us, between myself and the CEO, sign off all of those reports that serve at committees. And the respective executive heads of assurance providers, they're the ones who presented committees. So let's look at the PMC. We just one of the members, so I'm one of the members of the PMC, and there is no, as I already referred, the terms of reference do not say that we have a veto ticket. I am a member of EXCO. I do not have, or either the CEO have a veto ticket. I am a member of the valuations committee, and primarily because valuations are done within the finance team. So maybe let's go back and look at the expansion of the PMC committee. So prior to 2015, the PMC committee did not have assurance providers as members. So then post-2015, we started including them as members. So you had executive head of risk, executive head of legal, now becoming members of the committee. Then we expanded in terms of, because then there was a report that highlighted that we needed more investment professionals. You'll see in the unlisted, the members will become the executive head of private equity, executive head of impact investing, executive head of properties. If you look at the PMC of listed, because there's only one executive head, we expanded that committee to include the general manager of listed equities, the general manager of fixed income, the general manager of multi-management, to expand the composition of the PMC. Then we had the particular position being the executive head of research and project development. That was done just to make sure that we align with the strategic asset allocation and to provide research into investments that take place, to provide guidance towards the team, the investment teams. So if you look at what happened prior to 2015 to post-2015, we expanded those committees so that you have more deliberations and you have more people with the prerequisite knowledge. Finance was included because we're part of parcel of one of the legs of assurance provider. And I think there's already been presented that the PIC goes with the combined assurance model, understanding that there's a respective people that sit through. Then we even expanded that, in that if you look at the terms of reference, there are people who are standing invitees. They cannot vote at the meeting, but they are part and parcel of deliberations. So we looked into all of that. So we, just to continue answering question. So in my role, and I'll try to, so in my role, I have a delegation in terms of how much, which is higher. So you'll find that I'm only, now I'm talking day-to-day transaction in terms of corporate. There's a delegation that I have that from that amount, I should sign. There's an overarching delegation in terms of the general manager finance, and that at a certain amount, which his limit is very low, at a certain amount, he needs to sign and confirm funds are available. Now, just to clarify, in terms of AUM, the treasury function does not sit inside the CFO's department. It sits outside. It sits within the fixed income department. So the fixed income department, so I'll make an example. Our biggest client has 4 bank accounts. One is the main bank accounts. The other 3, there's an EC buyer bank account, there's a listed team bank account, and there's a properties bank account. But it has a main bank account which most transactions take place in that bank account. So we would, so in trying to put together liquidity, the fixed income team is the first team that will liquidate something, then comes to finance for payment, and that's the structure. That's the process of going. In terms of corporate, you'll see the financial statements of the PIC on its front page in accordance with the Companies Act. It's clearly stipulated that these are prepared under my supervision, meaning that I will review the financials. I'm responsible for putting conditions, controls in place to make sure that I'm able to review the financials. So the structure will happen that the team will prepare, the general manager of finance will review, I will also supervise. So the key, I do a couple of controls. If you refer to the PFMA, and it clearly highlights that each official within the PIC is responsible to design controls. So every department will design controls within their space. So each investment will design controls within their space to make sure that everything is in order within their space. So let's go with unlisted. So I've got it up to a certain asset result. So I sit in the PMC as a member, and then as it comes to disbursement from a certain limit, I will be, there's a limit that goes for the executive heads when there's disbursement. And if you check disbursement memo, there are assurance providers that come before anyone signs. You've got risk, you've got the deal team itself, the head of the deal team will sign to recommend the transaction. You'd have the legal guy signing, you'll have the risk signing, then you'll have the executive investment management signing. You'll always have the finance manager signing prior to me confirming my funds available and the ultimate authority, depending on the amount sitting with the CEO. Then when it comes to human capital, which is remuneration related stuff, so at a certain grade, all the executive heads will sign for their appointment. If I recall clearly, is every grade up to D. From every grade from E, I think the CEO signs, I will confirm funds available together with the general manager. So the executive heads have the autonomy to decide up to a position of D who they want to employ. And I will not be privy to that signature. I don't know if I need to elaborate further.
I think that's okay for now, because that's form. That's form. I think it does not take account of either informal and what we've had evidence before here, but that's how you see your role. That's fine for now.
Can I just add to that, perhaps, for you, Mr. Commissioner? Can you just, in addition to that, you sit also on investee boards. Can you just identify those?
So maybe just first to go back to at the point when you say informal, and maybe just try to understand.
I think proceed with what Advocate Libba has asked you about sitting on investee boards. It was part of my original question.
Okay, but can I just clarify? Because one thing before I proceed with that, through you, Commissioner, if I can. I've got a cross-functional role. I'm a specialist, meaning that there's certain elements I'll get to see. So when there's a capex especially in corporate, there's a capex budget that needs to be happen, my cross-functional role will go across everybody, because financial sustainability is one of my key KPIs, which has been sub-delegated to myself. And then the question regarding sitting on boards. So I'll answer it background and then come back to it. So the sitting on boards, so the employees of the PIC are permitted to sit on boards. So, and this is standard practice. If you look into the market, there's a policy that governs it. So they sit on boards. Myself as the CFO and the CEO, as we are also employees, we are permitted to sit on boards, but in its nature, we tend to sit on specific boards that are more strategic. So, and this is aligned. If you look at the likes of All Mutual, you look at the likes of Coronation, the CEOs tend to sit, especially in the subsidiaries. So you've got that part, so that we will sit. So I will sit in terms of, let me go back to the ones I sit in. So I sit in URBA. I used to sit on URBA. URBA, because it's a key strategic entity that was aligned, because they regulate the auditors, and as a key stakeholder and how much we play in the investment space, it was quite key that we sit there. So that was the approach we took. I used to sit in the regulators of accounting standards, and that was advising the Minister of DTI. The view even there was that it's quite key that the PIC sits in that role, in that it's guiding the type of financial, because we are the recipient of financials, so to guide, to make sure that the necessary disclosures that are there are in line. I sit on the board of IDC, so that predominantly was to ensure that the strong relationships, to strengthen the relationships between the PIC and IDC, because we found that in the space that the economy was currently in, it was needed that the two players, even though the one is a DFI, the other one's an asset manager, they are aligned. So then I sit on a board of, GRIT. So that was one of the biggest property investments we did in the rest of Africa. So, and aligned with that. So what will then happen is that I'll sit in these boards and I'll represent some of them directly the PIC, some of them indirectly. So the likes of URBA is just because of my part in terms of the PIC. So if I refer to GRIT, GRIT is listed in the London Stock Exchange and also in the JSE in the Mauritius Stock Exchange. Its primary residence is in Mauritius, so meaning that we have meetings that happen in Mauritius, in London, and wherever it's applicable. Then and then recently, about 2 years ago, it did a co-investment with a company that is based in Abu Dhabi, which is Gateway. So it did a development with them. So you'd find that vocationally, I've been to a meeting that took place in Abu Dhabi. So it was an investor. We went there to meet the investor, and the investor had invited us. So we had meetings with the investor. One of the kids, it's a private equity fund. So we had meetings with that. Post that, the management had organized activities. Then post that, we then had an investment committee. So this board also has meetings in Singapore, depending, because one of its key investors is around the world. So they then have investors, and I think the last one, which happened now in March, which I didn't attend, was in Abu Dhabi. The year before was Singapore, and I think I also didn't attend that. So you have that. Oh, slow down. So you have that. So if I then look so you have that setting. So there's been discussion to say the importance. So for me, and I'll give you my personal view.
Sorry, can I just conclude? Do you sit on the Pareto board?
I used to sit on the Pareto board. So if we recall, it was one of our biggest investors in investment in Pareto. So I used to sit on the Pareto board. Because of Competition Commission, I was then, a non-exec was transferred to the Pareto board, and I sit on the Property Com of VNA. So, so just a general, and on a personal development level, so sitting on the boards, and we've had deliberation, we also see it as an EVP, an employee value propositions, and we see it as an informal training also for us as management and stuff, because it allows us exposure to communication, interaction, and allows us to also experience different things, how they're done. And I believe we then add that into the whole employment, because then you get to see how other organizations are operating and get to view that. I think I've covered.
Can I just ask a couple of questions on your view of the boards, given what has come out around VBS? Would you consider that an employee value proposition? And the fees for boards, for sitting on these boards, does that go to the PIC in all instances, or does that come to any individuals? And then my third question is, you raised the question of financial sustainability as a key function, which I would certainly think it would fall into your purview. If one takes the Isibaya fund, the information that came to us in some of the hearings was that about 45% plus is either under watch, non-functional, certainly not returning, not giving returns. Have you looked at what that means for financial sustainability? And then perhaps in relation to, let me start with those for the moment.
So I'll start with the VBS. My first answer will be, you can design as many controls as you could, but collusion and fraud, you put as many controls in place. So one of the things we're looking into is that we should change in that assurance providers should not sit at the board, because their role is to have oversight and watch. So if you look at the VBS...
Would that apply equally to you as CFO and the CEO, given your roles?
So it could be applied, so you could look into it and apply and say where the controls. So we were busy reviewing the structure. So I haven't gone through the details to say, but we're busy reviewing to say, how do you put measures into place? So when you look at CEO, CFO, it's actually different, because if I look at some of the entities where it's the big subsidiary, and if you look into the private sector, you'd have the CEO being a board member there. And the key for me is you need to put checks and balances in place. So like I've highlighted, this was a discussion to say, what are our lessons learned in VBS? And how do we put together controls to ensure that we have the ability to detect it in future for it to happen? So that was so we were looking into revision of that policy and to see how it works. In terms of...
just in relation to that, are you also then looking at how you deal with fiduciary duties?
So let's go...
Well, the fiduciary duty, a person who sits on the board has a fiduciary duty to that entity. what is it, how do you deal with the fiduciary duty to the entity being PIC senior executives responsible for risk sitting on a VBS board with a fiduciary duty to VBS and sitting there on behalf of the PIC precisely to ensure that there is good governance and so on, which has clearly failed, not only in that instance, but in that. So have you looked at how you're going to deal with the fiduciary duty if you continue? Because there's a duality. There's an expectation of a fiduciary duty to the PIC and there's a fiduciary duty to the entity. Is that part of your review? Are you looking at that question?
So just to answer, so these were projects that were still embarking prior to my suspension. So after my suspensions, I actually don't know because we hadn't finalized. So I planned a workshop with the assurance providers so that we relook at our control. So I don't know how far the PIC has gone through because I've not been around for a couple of months. In terms of fees, so...
I'm sorry to interrupt. I think what we need to understand is, while you were still there, what's your view?
So like I was highlighting that we were starting to look at lessons learned, to root it, not just be, this is what happened, where was the weakness, where did the investment management team, what didn't they look at? So the key with this issue is just not to look at it at one, but to look at the holistic picture and see where, because there's no point of plugging a hole where you think there's a wound. The key is to understand the bottom part of the wound and make sure that you've addressed everything correctly. So that was the process we're going through. So I'd asked the assurance provider that we look at. We had a workshop with all the investment teams to go back and relook at our entire processes to see which sides there were blind spots that we need. So it's not an isolated thing that you just say plug, because you have to go deep and figure out where all the weaknesses are. In terms of fees are only for PIC employees. The fees are paid to the PIC, and this we took all the way to a constitutional court where we won that any employee that's being represented by the PIC, the fees go to the PIC. As it relates to non-executive directors of the PIC which are placed on the board, their fees go to them in their personal capacity.
Can I, sorry to interrupt you again.
Mm-hmm.
The constitutional matter you referred to, is that the one Ms. Pamela Pashler testified about?
So it's Kagiso Budjigelo, yes.
And if I remember her evidence correctly, there was initially resistance within the PIC to say, no, if we sit on a board, we want that director's fees to be paid to us. It mustn't go to the PIC. Is that correct?
I'm not sure who she's referring to, so I'm not sure when said there was resistance. I'm not personally, if you think about it, if you think about that case, there was always the standard norm at the PIC that employees, their fees go to. It's just this one individual who believed a bonus that was paid to go. So I cannot comment on what Ms. Pala was referring to.
Thank you.
And then in terms of financial sustainability, so it is quite important that the management of the Isibaya portfolio is looked at. And it is quite critical that we look at the whole picture. So is it worrying? So it is worrying when you have impairments, because impairment means you're losing, it means technically there's a drop in the value. So as when we're starting to look to say, there's certain entities that have taken a knock because what has happened in the industry, what has happened in the economy, and the impact those are taken through. So we are looking...
Do you look at the condition, because that's saying the reasons for their failure is general circumstance. Are you also looking at the process to approve those investments as to whether you've made good or bad investments? Not whether there's a technical process of form, but what did you consider and where were you wrong? If one looks at some of the references about, that were discussions about all the risk criteria that were seen, for instance, in MMI, were the pluses when you made the investment, and when the things fell apart, they were all exactly the same, but all the minuses. So the things that were regarded as good were all the things that were, by the same risk assessment, the weaknesses. So for me, the question isn't just the form. The question is, Are you examining the process by which you look, I mean, your mandate is transformation, economic empowerment, trying to see that we build this and grow this economy. If you've got a 45% failure rate in that investment, what do you examine? It's not the form, it's not whether the economic, there may be circumstances where it is economic conditions, but that can't be the approach of the fund. And then while you're responding, I'd also just like to ask, when you have a situation where an investment does not pay, does not service its debt, what steps are taken? Again, we're going to come to the IO transaction, but if you take the second Jalo group, you've got independent media with an outstanding debt of close to R1 billion that is not being serviced, yet further investments were made in the group. What, as CFO, do you assess that to be? That one's profitable, the one we take a loss on? I don't understand if there's a non-servicing of a debt, further investments taking place without that debt being serviced.
Okay, so
Relates to the question of financial sustainability.
that's fine. So let's go back to what we were doing. So if you look at the evolution of our processes in terms of investments, we're forever trying to change them to adapt to that. So when I was just saying industry, that was the first part. So we were looking into the processes, and that's why even we started the process of deal screening. That's when you see the membership of deal screening, we're looking into more of the team of research to come in to start isolating, to say, what is happening here? What's happening to this company? Or what is actually, is it sustainable? Looking at more of the due diligence process, looking at how to enhance due diligence in terms of more due diligence to be able to pick up the issues. So, and the key when I highlighted the assurance providers to look at how do we start assessing, where are weaknesses. You'll find that the post-management team would put together lessons learned in terms of investments. So those have gone down, that will put together lessons learned to try and identify that, where did we go wrong in not detecting this? What more can we do to improve? So let's leave the industry because what would happen, but now we're looking at the entire value chain within this PIC to say, let's go back and look. Hence why one of the key things I was embarking on is to sit with the assurance providers and say, where's our blind spots? Why aren't we able to pick up the ones that are really not going to, when the market goes down, they're going to take pain. So we look at, so we had a workshop, and the deal team had a workshop. So to put together, to say to review their processes, to review what's happened. And I think the big thing is also that we wanted to put more accountability to the fund principals, especially in the unlisted, that they partake and they criticize each other. So one of the key things we're looking into, which I'm not sure if it's still the state, that the deal team being the first committee that looks at, so the deal screening committee, to not be actually members of the PMC, but to be different members, to be fund principals, so that you're starting to have more eyes, more different eyes looking and interrogating an investment. So having an impairment, it is a worrying fact, and it is a worrying fact, so keep on monitoring. And one, I think the criticism that we're getting is, at this current, our rate of investment is not as fast as it used to, but it's because we're more cognizant to say, now we need to really dig deep, drill more, take the lessons we've learned and start applying them to our processes. So the servicing of debt. So there's certain investments which the debt is contractual to say when do they start servicing it. So you'd have, and if I recall, memory serves me clearly, the first part at INMSA, the debt was only due at a certain date, which was then a potential default. So one of the things we're looking into, which I'd asked the legal team to start looking into, we'd ask as PMC, is our contract strong enough? So if you look, we did a policy that we call it the funding guideline policy, which started saying that our security should not just be the shares of the entity, but we should start taking personal surety from the investing company, from the sponsor of the investment, so that you ensure there's alignment of interest, because sometimes you find people, the only surety you have, the security, the shares company, but their personal wealth is not affected. So we've looked at things like that. We introduced the concept of skin in the game. So meaning that when you want a certain shareholder equity, there's a certain amount of money you should put in, being skin in the game. So, and those are more to align our interests between the sponsor and the PIC. So now you refer to Sekunjalo. So Sekunjalo, my details of Sekunjalo are not that strong, because it took place when I was on maternity leave. So now we're putting together a policy that is saying sponsor. So looking at exposures to sponsors to make sure that we're starting to limit the exposure to one single sponsor, to start interrogating what happens. And when we come into my further statement, when we deal with IO, we'll have the discussion in there where I elaborate to say what risk highlighted in terms of related parties. Sorry, is there any question I've left behind? You come back. Okay.
Can I, yeah.
Yeah, all right. Can I just ask you, if we could just go back to your restructuring. When Minister Gigaba said don't change the MOI, had you already restructured? Had you already done away with the other positions, CIO, COO, etc.?
Yes, Commissioner.
And you are still continuing with that, even though the MOI has not been changed?
Yes, Commissioner.
What impact does that have?
In terms, legally, I'm not sure. I'll have to find out from the assistance from LOG, so I don't want to speculate to say what is the impact with when there's inconsistency. I would not want to comment. I'll rather further find out what legal says, then provide that input, sir.
But of course, you realize that you are now outside of the, and I think it's paragraph 7(1)(11) that says the board shall appoint these people into these positions.
In the MOI, sir? I'll look at it in the copy if you allow me to come, because I don't have a copy with me in front.
All right, you can have that opportunity, but I say that it says the board shall appoint, which is a must.
So, Commissioner, if maybe one of the things is the board was having that discussion, the appointment of those positions, and I know that there were deliberations and even the review, we're actually in the process of re-reviewing the structure to go through, and that they were busy with the appointment of those positions, but I'm not fully aware where they are right now, but I know there were discussions.
Just to follow up on a couple of questions, Ms. Moray. MOI, it's a Companies Act thing, and maybe we should check whether if you do a restructure before changing that document, are you in contravention of the Companies Act or not? And you go on for a number of years doing that. So I'm not sure. I was trying to recall, but I'm not sure what the position is there. It's the first question, yeah. The next one is, when you do away with a COO position, that position, is generally meant to relieve a lot of pressure from the CEO, So when you do away with that position, don't you burden the CEO with a lot of work which he shouldn't be doing?
So when we did away, we created the executive head of corporate services, but in doing it, in not having a COO, we took certain departments that were previously had senior managers, we actually elevated them. So let's look at what used to sit inside the COO. So we created the executive head of legal, because previously there was just senior managers. So we had an executive head of legal with senior management. We created before the CEO, about I think around 2013, IT used to sit inside the COO. We elevated it and created the executive head of IT, and we then included more, we broadened it more. So then, if you look at HR, we compared to other people, other institutions, and we looked at it that it is quite critical to elevate that position. So we elevated it. Previously, it used to have senior manager. It's a senior manager of HR. We found that it was critical to have a specialist. Hence, we created the position of the executive head. So we actually elevated positions that used to sit underneath COO as being just senior managers. We actually elevated them. So and I highlight those because those are cross-functional roles in that they are specialists. So they advise anybody in the business. So they're not just advising the CEO. So they advise all of us.
Right? Yeah, but don't you think that these people are there as, top heads of the companies, but they still report to the CEO, meaning the CEO still has that burden of listening to these people, unlike if they were within the CFO role, which the CFO would listen to such people?
Maybe can I ask you elaborate in terms of burden? Because if I look at the delegation of authority, there's a certain level, the only time they need. So they'll report to the CEO on operational matters, administrative function. But in terms of specialist, you have an executive head of HR would advise executive heads and doesn't need the consent of the CEO. So I'm not sure if when you say the burdening of the CEO, in what sense, sir? If you maybe can clarify it for me.
Yeah, so in companies where HR, IT report to the COO, then the CEO doesn't need to meet the heads of those divisions because they meet the COO and then the CEO just report to the CEO. Am I clear?
So maybe to find, so we, like I've highlighted, that we looked at other companies similar to us, we had the two executive. So you'd find that the two executive directors being the CEO and the CFO. So you find that the corporate part of the business, corporate services would report to me, but more of a administrative because they're specialists. So the regular meetings, they take place, with all of us even at EXCO, but more specifically, like, I don't know to say, they would highlight, so key strategic things will go to the CEO as it relates to, and it will be key strategic things. So the day-to-day administrative function, the day-to-day, so we put more responsibility on the executive head, and that is not about the CEO. You'll see if you look at the delegation of authority in terms of the executive heads, we actually elevated beyond the power they had during the times of COO, CRO. We gave them more delegation so that you stop having the executive directors being a bottleneck in that they have to do the decisions. And so that's how we looked at it, and that it's quite critical to have specialists that advising.
All right, let's go to the next question. I'm going to try to stop you and ask questions as we go along, yeah? In terms of the role of the CFO, we find that property reports now to the CFO, and Mr. Chris Pulani reports to the CFO. I mean, does it sort of happen often that you actually have such a structure in large asset managers?
So when we looked, and I think I would like just to maybe to highlight a certain point. So the reporting to the CFO is more of the administrative function. So you will see that in terms of the executive head of properties, I don't sign off as a final in terms of the investment. So they will still sign off as executive head a deal that goes into the property, into the PMC regarding property. So when we did the structure, and Mr. Pulani is the best person to answer, we tried to separate, to make sure that you don't have 15 people reporting only to the CEO, but to spread across. But predominantly, it's more of the executive heads reporting to myself is more of I don't want to just say administrative, but they're specialists in that they're they will cross-advise, so you'll have, they don't need to via through me to advise another executive head. They're specialists, so they'll advise the CEO directly. So even if, so when you look, so that's why we tried to break it into two. So if you're highlighting, have we seen it in other asset management? So not in particular that I can remember right now, but I can go back and look at that when we did the paperwork to say, what did we include?
Yes, I mean, just to say that to find HR, IT sort of reporting to the CFO, don't you find that a bit odd? In many companies, the CFO is just the CFO, and corporate service and COO are done somewhere else.
So just to highlight, so what we try to do, not have 15 people, and that's why I'm just trying to emphasize that as much as they report, it's more the reporting to me in terms, because I've also got a cross-functional role, just like they have the executives. So you'll find that I'll have, before they sign off certain things, which is a certain limit, I'll also recommend to them, where I'm not necessarily their supervisor, but I'm actually below. A case in example is to see the executive head of HR. It's him who signed off my precautionary suspension. So to show that these guys are specialists, so there is no limitation in what they do, but they service the entire business. So it was more of the HR will report to me just on administrative function, but the specialists, they key day-to-day work, they actually are supporting everybody.
Sorry to belabor this. So let me understand this. So Mr. Polwani, do you do his performance appraisal or is it done somewhere else?
So the norm that we did, the performance appraisals of the executive heads, we actually did together, myself and the CEO. So it was not in isolation, we did it together. We'll both have a view, and when we met, the executive heads will be together. The one part where the executive will tend to, the CEO will meet by himself is the investment teams. So when it comes to a support structure, we'll do it together. And you'll see there'll always be where there's two scores, and I think Mr. Polwani tried to highlight the process that we embark on when it comes to the moderation of the executive heads. That is just the two of us will sit and analyze, will sit and compare notes and take that to the HR committee for final review.
Sorry to belabor the point. So who does, when you say reporting to, who does Mr. Polwani report to?
So on a solid line, he reports to myself.
I think that's the point, really. So IT, who actually reports to?
So on a solid line, they report to me.
Then that follows my question then is, don't you find it odd that these people report to the CFO, whilst in many companies that is not the case?
So when we did the research, in some companies actually they do report to the CFO, bring the two. That's why I started saying the first part is we looked at other companies that you have the two executive directors. Some companies, the position of HR is actually an executive director position. So it's not just below the part. So we find, and I can't remember the companies, so we look, and if you spread your research just beyond just the asset manager, you'd find that you tend to have, like if you look at other fund managers, the small ones in predominantly, you'll find actually HR does sit inside the CFO that they don't have. So it just based on how we look, and that was the design of the org structure, and we looked at certain inputs, and further I can go back because I didn't have access to the details to put together the details that came to that.
Let's make a move on. Next question is on the PMCs and the CEO and the CFO sitting, or they need to be present in these meetings. Don't you think that, that slows down decision making when you sort of have to have such a centralized structure with CEO and CFO having to sit in all the meetings, that the investment teams cannot make their own decisions, as you see at Sanlam, Mutual, and such companies?
So through you, Chair, you'll see, through you, Commissioner, you will see in the revised terms of reference, they don't need, so previously they needed to be present, for quorum to be made. And that was predominantly because then indirectly they the one, when we get to the board committees, it's a sign-off of executives. So because we identified that being a bottleneck, the terms of reference were changed, that they actually don't need to be present in the meeting for it to be considered corrected. So we did identify that that's a bottleneck. So if they're not there, then even if the quorum is met, then it's not. So we did change that.
Next one. When there are transactions coming to the PIC, you find that they are recommended by the CEO. Sometimes the CFO, the DMST transaction was brought by you there. Don't you think those two big people, I would say CFO, CEO, being part of the investment team and recommending transactions also, doesn't that put undue pressure on the investment team, where actually the CEO can say this transaction is going to succeed here?
So through you, Commissioner, I would like to elaborate. We don't recommend, we submit. So maybe to say that's a big word. You never recommend to say, guys, do this investment. We submit. We've got proposals that come from the chairman. We've got proposals that come. So we never say, we recommend for you to do this transaction. It's here's the proposal. It's for deliberation, for consideration. So I would like to think, I'd hate to believe someone interpreted, and I've got transactions where they came into my inbox and I forwarded it and they were declined. So it's got nothing to do that we then tell the teams that this transaction must happen. No, we don't recommend, we just submit.
And partly I'm asking this because we had, I think it was Mr. Sunil Vagis, and I think it was Victor Siani, saying that there was a time they had problems with some transactions, but they had to find a way to make it work, this is what they said, or to find a way to say, let's put negative stuff such that this transaction can be sort of rejected because we don't want it, but we really feel we cannot go, against the powers that be. That there was that kind of pressure to say the investment team doesn't want this, but really we are scared of the powers that be.
Through Commissioner, that's a difficult question for me to answer because I was not privy of which pressure they got, how they got the pressure. Is it just a submission being made equals to pressure? Because I've seen transactions that were declined on my side. So so I saw that comment that they made before the commission. So it's very difficult for me to answer, to say, is there pressure? Because I can tell, you just submit proposals. Therefore, I would never said you have to approve this transaction.
Okay, the final question from me for now, and this is just a separate matter which I just want to get from you. Just in terms of the PIC, is it a profit-making company, or is it you can just make enough profit to succeed, to sustain yourself? I mean, what is the PIC? Because it's got a bearing on the salaries which can be paid and all that. What does it do in terms of profit issue?
So it's been one of the discussions that has been having to go. So as things stand, we have committed to the shareholder that at a minimum, 10% of our management fees shall be, so net profit at a minimum will be 10% of management fees. And in the event that KPI is not met, no bonuses will be paid to make sure. So we've seen it as a sustainable, that we should be financially sustainable, so we should be able to sustain ourselves. Hence why we've got such a KPI for ourselves that there's no incentive unless you're reaching the 10%. So as things happen, so one, you have a deliberation that are we a profit making. So if you look in terms of the fees that we charge our clients, they're not market related. So they, especially in the listed space, they're lower. So we don't charge a performance related fee as it relates to the listed space. So when we did a Sibaya and we introduced Fund 1, that's when we're starting to balance the fees to say, okay, we won't go all the way to market, but we look at it, and that was predominantly restructuring. So if you ask my personal view is, we should never be in a position where we are not financially sustainable. So even when you balance out the bonus and everything else, we should be sustainable. We should not be in a position where we require the fiscus to bail us out. Hence why the board has always taken the view that if there's not 10% of net profit, of management fees reserved, there's no bonus. So that's a KPI. You'll see it is even in our remuneration policy that it's sitting there. But like I've highlighted, it has been a debate in terms of, and you've got that the human capital is increasing as you are moving towards the org structure, filling up the whole org structure, but the revenue line is not growing in the same direction. It's growing up, but not at the same rate.
So basically then, given the fees that you are getting, you can say that you are not like Coronation where you maximize profits and all that. Is that correct?
Can I just ask you to elaborate? So we're not having a high performance. So if you look at the listed space, which is accounts about 90% of our portfolio, so the fees are not market related. So they're not, we don't have, and that's a discussion we've had on the board that maybe we should approach the client and have that discussion so that it also aligns, it aligns the investors, that is aligned that if there's no performance, it's got an implication. But if you look at our track record, we've been able to perform and exceed the benchmark. So we have been able, and I think the key thing comes, and the deliberation comes for, where do you get the talent? So the talent that you have to manage this portfolio, you're actually getting them from the private sector. So therefore, there must be a balance. And I think we're putting together a paper to find how do you do the balance.
Thank you. Thanks.
Mr. Commissioner, may I suggest we have a tea break? It's a tough, intense debate, and I think the witness will also need a bit of sustenance. Can we have a 15 or 20-minute tea break?
Can I just ask one question before we do that, if you don't mind? Just from everything that you've said so far, notwithstanding the over 70 witnesses who have been here, as far as what has come across to me is that you're satisfied with controls. Yes, you're doing a review, but controls are in place. You're satisfied with the restructuring. Your executive heads are specialists and they perform their jobs appropriately. That having two execs is in line with what you think the market generally does and does not create a concentration of power and authority. Would that summarize what you've put across?
So just to, in my view, I'm not saying it's satisfied. I'm not saying I'm satisfied with the controls. Let's go. So the structure, we did a structure in 2015 and there's been an evolution. And if you look, previously we had actually submitted to the board that the reinstatement of CIO been put in through the COO, we had put in a structure. So I think the word satisfied, it's not satisfied, it's an evolution. So at a certain point in time, something works, then something happens, then you realize that that thing has loopholes or it needs to be enhanced. So if you talk about controls, we have to improve on our controls. We have to improve on the second line of defense. We have to improve on the third line of defense. We have to improve on the first line of defense because certain events have taken place that shows that we have to improve in terms of that. So even the structure, there was the discussion that we have to relook. And even if you look at the approval that took place, it did highlight that relook at the structure, see if it's working, see if it's optimal, see that is it achieving what we envisioned it to achieve. So adding two more executive directors, I support. Add two in order to ensure you enhance the structure. So, and like I have highlighted, you know, you had the likes of VBS that took place. You have, it's a process. Even if you've looked, one of the recommendations we're making is that maybe have more ICs of different members so that you're actually able to protect the insider trading, competition, conflict and stuff. So I'm not going to say it's satisfied. My words are not satisfied, is that it's subject to review. We need to review and relook at it. And I think that was the purpose of this commission, to have a deliberation, to hear information and to assist the PIC in making sure that it's getting to the optimum level that at the current present moment that we would be able to, because in 3 or 4 years that could also be reviewed because certain events take place.
Yeah, I understand the question of review, but the purpose of the commission is impropriety, actions of impropriety in the PIC. And that is clearly something that is the core issue of what is happening. An acting board, acting CEO, acting CFO, a great deal of acting positions. And I would, my question is that yes, always, any organization reinvigorates itself through review. Nothing is static. But what has not come across to me is the question of saying, how have you as a CFO, being in a responsible position while all of this is happening, challenged your own appreciation of what you're doing? Because maybe it'll still come as you read your statement and we have further discussions. Okay, thank you.
Just a quick one here before we go. I'm looking for your view here. Just in terms of the CEO being able to make investment decisions. I mean, in some large companies, actually, the CEO is removed from investment decisions. And at the PIC, you got the CFO, CEO being involved in these decisions. Don't you think sort of the best practice is to separate those two?
So as part of the review, we were now starting to review to say, okay, if the 2 or 3 executive directors are members of PMC and they're members of the IC also, what is the implication? What's the risk? How do you manage the risk? So it's a very, like if you look at the respect, and I look at some of the DFIs, that you have the CEO who is part of the management committee. But now the look we're looking at it, is it at the right, should they be there or should they be at a certain level? And then how do you manage that they are part of PMC and part of the investment committee? So it's not a straightforward answer of saying remove completely, because for me, in my view, is that the minute you take a document inside a board committee, it means as management, we supporting that document. So, and it's because at the end of the day, all of our responsibility comes from the accounting officer. So we need to strike a balance to say, okay, has an accounting officer in accordance to PFMA and that the buck stands with that position, how do you manage that responsibility and accountability, yet managing the conflict?
But then how do you hold the investment team accountable if you are part of the decision making? I mean, one of the biggest problems at the PIC is that no one is held accountable, in general. So if there are missteps and bad investments, it looks like no one is held accountable. Because it's all a committee decision making structure.
So I don't want to say no one's held accountable. If you go and look at the investment team's balance scorecard, you will see that about 50% of their KPI, of the weighting, is actually with regards to investment. So you have, and you'll see, so if you look at, and I think Mr. Polwane highlighted, the way the BSc is done. So we all have a certain element at corporate, but our weightings differ. So if you look at my BSc, the financial sustainability parts of my BSc have a bigger weighting. If you look at the investment team, the client and stakeholder part have a big weighting, about 50%. So I don't want to say that they are accountable, because it formulates part of their KPI that they need to meet this, they need to meet the target. And if you see about the performance information that is in the agreement we have with the shareholder, you see performance coming there. So you see performance coming into the CEO's BSc, but you also see it coming in through the respective. And when you look at the respective executive heads of investment, it's even broken down to a further detail. And what then has to happen is they take that part and then they translate it to the general manager. So if you have the general manager of listed equity, you'll see a big of his KPI will be the investment. So as Mr. Polani, I think in his statement he highlighted that this is a process of review, and we are looking at it and how to enhance it, just to make sure more accountability. And like I said, the big thing is the weighting. So I don't want to say they're not accountable. They are accountable. It's sitting in their balance scorecard inside their KPI in terms of performance.
It sounds odd if I were to say, let's come back at 5 to 12. All right, can we take that? I think let's take 15 minutes, and that will take us to 10 to 12.
Thank you, Mr. Commissioner.
We'll adjourn until 10 to 12. Thank you. Yes, Ms. Mori, you're still under oath.
So, thank you, Commissioner. So I'll commence with Section 3 of my statement into allegations and/or insinuation of interference with the work of the Commission. The purpose of this section is to address allegations presented to the Commission to the effect that I, in my capacity as the then acting CEO of PIC, interfered with the investigative work of the Commission. I wish to point out at the outset that it was mainly based on these allegations that I have been placed on precautionary suspension. I attach here too a copy of my precautionary suspension letter marked as Annexure MM01. It's to be noted that according to the precautionary suspension letter, the said allegations are contained in correspondence received from the evidence leader of the Commission, Advocate Lubber. I categorically deny that I've done anything that interfered with or has the effect of interfering with the work of the Commission. In order to demonstrate this, it is necessary to outline what transpired prior to the board taking a decision to place me on precautionary suspension.
Tell me, did you ask for that letter that was allegedly written by Advocate Lubber?
So, through you, Commissioner, no, I didn't ask for the letter. On 8 March 2019, Ms. Lindiwe Dlamini, acting as Executive Head Legal, and I reported to the Board of Directors of the PIC that there were some staff members who indicated that the investigators of the Commission requested them to provide statement in MS Word, and that they were not comfortable with this request. I attach as an example a copy of an email received from one of the employees who reported this concern to management, marked as Annexure MMO2. It is to be noted that this particular employee mentions the name of one of the investigators that made the request. Further, some staff members indicated that they were incurring legal costs as a result of them having to seek legal assistance in preparing their statement to the Commission. I attach marked Annexure MMO3 as an example, an email from one of the managers highlighting that her team continues to inquire about some form of legal support. It is important to note that the inquiries referred to above are just examples of the formalized requests for legal support. I am aware that several other employees harbored the same concern that were reluctant to make requests formally. In order to address these concerns of the staff members, we, being Ms. Dlamini and I, made a proposal to the meeting of the board on 8 March 2019 to effect that the PIC should appoint an external independent legal firm to assist employees on a voluntary basis in preparing their statements to the Commission. The board approved this proposal. I attach here too a copy of the board resolution marked Annexure MMO4.
I'm sorry, I'm going to interrupt you now. Can you recall that when we had our first meeting, we agreed that we will approach this Commission on a friendly basis, and that the PIC will act as a friend of the Commission?
We will agree. I'll confirm that. But Commissioner, can I just request that I read it through so that then I can give a context to the answer?
No, I'm going to give context now further to this, because following on that, I advised you, and you wrote a letter to the board dated the 15th of January, to say that I need information, but I also advised the board to appoint senior counsel with knowledge of Commission work and a firm of attorneys to assist the board. And that the board did.
So through you, Commissioner, can I kindly request that I allow, so to give context to how it comes in with the two separate appointment of legal support?
No, you'll have the opportunity. Can we just please just deal with my questions first? You'll have ample opportunity to deal with it.
So maybe Advocate Lubber, could you repeat what's the question?
On my advice, you wrote to the board on the 15th of January that they must appoint legal counsel, senior legal counsel, and a firm of attorneys to assist them and management in dealing with the Commission work.
So to confirm, the legal counsel that was appointed was to assist the PIC and its board and management, not the employees. There was a resolution that it will not assist the employees.
there was in fact an agreement, and we'll come to that, and if necessary I'll call Mr. Poswa, that he will perform a workshop telling the employees how to go about making statements, what is the difference between an affidavit and a statement, etc.
Just to Commissioner, through you, this is a request that employees made. So this meeting that what we approached the board on the 8th of March is regarding a request that employees directly made. So, and I've highlighted as part of my annexures where they formally requested. So over and above Mr. Poswa's request and this communication regarding him having a workshop, employees directly approach myself, approach their managers requesting assistance when a concern. So this is, and the reason why I was asking to read my statement to complete is to highlight what they were looking into, because POSWA is still appointed to support the board and management regarding the issues of the commission.
No, but I think the main question is that there was an agreement that senior counsel and an attorney will be appointed. Was there such
an agreement that senior counsel were appointed to assist the PIC. I confirm that.
We'll get to the workshop later. If I may turn to Annexure 4 to your statement. It deals with the extract from the approved minutes of the board meeting held on 8 March 2019. 14.3, at this stage of the proceedings, Mrs. Lindiwe Dlamini, Acting Head, Legal Services, Governance and Compliance, joined the meeting. The board noted the report on the appointment of legal advisory services contained in the meeting pack. The board raised the concern that the scope of POSWA Incorporated should be reassessed, as the board did not receive any value from them since their appointment. Advocate POSWA is one of the senior advocates in the country, and PIC was paying a lot of fees for these individuals when in fact it is not even clear what value they are bringing to the table. Factually, that statement is not correct because POSWA is not an advocate, he's an attorney.
So I cannot comment. So when these minutes were approved, I was not present. When they were approved by the board, it's just an extract that I asked from the PIC. So I can only give you details regarding to facts that I know.
14.3.5, management, and I suppose that is you and Dlamini, highlighted the gravity of the situation from an employee perspective. Some employees were requested by the forensic investigators to provide their statements in Word format, which means the statements could be tweaked by the investigators. That is what is now represented by you and the acting head legal to the board. Am I correct?
So through you, Commissioner, if you allow me to read through my statement, you'll actually get to the part of the verbatim, which transfers the verbatim.
We're coming to that. We're coming to that, Ms. Morey. We're coming to Annexure 6, because I requested the verbatim and you requested that. And it is an annexure to your statement. Is that correct?
Yes, it is.
Now let's read the verbatim.
Through Commissioner, can I please maybe request that?
All right.
Because it gives context to the verbatim.
All right. I think let me give you that opportunity. Read. How far do you want to go before coming back to this issue?
So coming back, when we get to the verbatim, then I'll take questions on verbatim, but I need to give context to what transpired because it then provides explanations, and most of the questions are sitting in my statement. Thank you, Commissioner. On 13 March 2019, Mr. Alvin Edgar Shiel, made a statement during his testimony to the effect that there are rumors that individuals who have been called to give evidence before the commission, before the evidence leader, Advocate Laba, are then summoned to account for this on the 7th floor. And that, open bracket, whether real or not, the rumor in itself is intimidating for most. I attach to the extracts of the relevant testimony of Mr. Shield marked as Annexure MMO 5. It is to be noted that from this extract that Advocate Laba, among others, informs the Commission that, open quotations, the board were informed that the evidence leaders asked potential witnesses to bring their statements in word format so that the evidence leader can chop and change. Close. It's inside the extract. Upon learning of the statement made by Advocate Laba, I then contacted the then acting company secretary to provide me with a verbatim transcript of the proceedings at the board meeting of 8 March 2019 in order to ascertain whether what we said to the board was correctly captured. In response to my request, the acting company secretary advised in an email dated 13 March 2019 that Advocate Laba had also requested a copy of the verbatim transcript, which he had already provided to him. I attach here to a copy of the verbatim transcript, as well as the email from the then acting company secretary marked as Annexure MM06A and MM06B, respectively. On the same day, 13 March, Advocate Laba addressed an email to Mr. Luyolo Poso of Poso Incorporated, a legal firm which has been appointed by the PIC to, amongst others, assist the PIC in relation to the Commission's work, confirming, among others, that Advocate Laba had alerted Mr. Poso to the board meeting of 8 March 2019. So I've got the Poso email. Advocate Laba further alleged that his team had experienced a marked reluctance by witnesses to assist the Commission because of our report to the board. I pause to reiterate that Ms. Dlamini and I merely reported to the board that Advocate Laba legal team may be acting improperly with regards to taking the statements from potential witnesses. This is borne out by the verbatim transcript already annexed here to marked as MM06A.
What do you mean by saying they may be acting improperly?
So,
what made you and Ms. Dlamini say that?
So if you look at the verbatim, it's actually Ms. Dlamini that highlighted. And my mere highlight is about that there's legal support through Commission. If I continue reading, you'll start to get a context to say what was the issue which Ms. Dlamini highlighted to the board. And you can get, because the verbatim actually says exactly who said what between the two of us. If you can allow me to continue reading, you'll get more clarification towards the matter. Okay. Advocate Laba further stated in Poso email that Ms. Dlamini and I did what Ms. Dlamini and I did, i.e. reporting the concerns of the staff to the board, constituted an act of interference with the work of the Commission, which, open quotation, may be a breach of the terms of the proclamation and may constitute a criminal offense, close quotations. I attach here too a copy of the Poso email marked Annexure MMO7. What was concerning to me with the email from Advocate Laba was that the mere act of reporting the complaints on the part of the employees and the request for legal support for employees was adjudged by Advocate Laba as another form of perpetuation of alleged victimization of employees by the, open quotes, very same person, as already alleged before the Commission, without me having been given an opportunity to respond to the allegations. On the same day, Mr. Poso sent a letter to the then chairman of the board, Mr. Mondli Ngungubele, and certain board members, including myself, and the then acting company secretary advising the board, amongst others, the concerns that Advocate Laba raised with him, the alleged interference with the work of the Commission. I attach here too Mr. Poso's letter, as well as the covering mail marked Annexure MMO8A and MMO8B, respectively.
Sorry, I've got a question. Do you want to continue, or can I ask a question, or do you want to continue to the end?
Can I continue to the end? But if you need, and then I'll jot down the question and answer it at the end.
Okay, no, it's fine. I'll ask it at the end then. It's okay.
Thank you, Commissioner.
No, I just want clarity. When you talk about the end,
No, the end of section 3, not the end of end. No. Thank you, Commissioner. On 14 March 2019, Ms. Dlamini at my instance, met with Advocate Laba in order to highlight to him that the alleged interference with the work of the Commission attributed to us is factually incorrect. I attach here to a copy of an email dated 15 March 2019 from Ms. Lamini addressed to Advocate Laba, copying the then acting company secretary, confirming the discussion and the understanding reached at the meeting, marked Annexure MM09. It is to be noted that Ms. Lamini clarified the role that the appointed legal advisor will play in relation to providing legal assistance to the employees. She further emphasized that the use of the service of the legal firm, open quotation, is a voluntary process. No employee is compelled to utilize the service, but the service remains available, close quotations. On 15 March 2019, Advocate Laba addressed an email to the then acting company secretary, asking her to circulate communication to the commission to the staff, titled Communication to Staff from the Chief Evidence Leader. To all staff members of the PIC, I attach here to a copy of the communication as well as a covering email from the acting company secretary, marked Annexure MM10A and MM10B. It is to be noted that the communication, Advocate Laba confirms the discussion with Ms. Lamini and mentions that the only reason for the request to have draft statements in Word is to enable the legal team to correct grammatical mistakes, to supplement where necessary allegation, or to remove unnecessary allegation, close quotations. Advocate Laba further mentions that he was informed that the PIC has appointed an external law firm to assist staff in this regard. This may result in delay in the process, but the legal team has no objection to this process, close quotation. On 20 March 2019, I was informed by the board at the board meeting that it had resolved to place me on precautionary suspension with immediate effect, subject to the approval of the Minister of Finance. After the chairperson of the board read out the precautionary suspension letter, I inquired what the exact allegations that have been against me were. The chairperson indicated that the board had already obtained a legal opinion. The precautionary suspension letter was emailed to me by Mr. Christopher Polwani on 26 March 2019. I attach here to the email from Mr. Polwani and the precautionary suspension letter. Please note, this is the version signed by Mr. Polwani only, marked Annexure MM11A and MM11B. It is to be noted from the letter that the board arrived at the decision to suspend me, open quotations, following correspondence received from the evidence leader of the PIC Commission of Inquiry, Advocate J. Laba, which levels allegations against you, close quotations. On the same day of receipt of the precautionary suspension letter, I wrote an email to Advocate Laba reminding him not to forget to provide me with topics which he required me to address in my statement before the Commission, as I understood that he had leveled some allegations against me with the board. Advocate Laba responded to my email on the same day, amongst others, denying that he had leveled anything against me with the board. I attach here to a copy of the email correspondence marked Annexure MM12. In the circumstances, I respectfully submit that the allegations of interference are unfounded and certainly not substantiated when scrutinized against the correspondence and documentation I have outlined above and attached here too. I merely reported to the board concerns that were raised by employees to management. At no stage did I attempt to interfere with the Commission's work or the work conducted by Advocate Laba. In conclusion, I want to assure the Commission that I will continue cooperating with the work of the Commission.
Are you now prepared to take my questions? I've dealt with the minutes. That is Annexure 4, where it is recorded, management highlighted the gravity of the situation from an employee perspective. some employees were requested by the forensic investigators to provide their statements in Word format, which means the statement could be tweaked by the investigators. First of all, that is factually incorrect. Not one of the forensic investigators asked that. One advocate requested that by the name of Sechaba, whose name is mentioned in the email, and he is an admitted advocate from the Johannesburg Bar. Let's turn to Annexure 6. Now, this is the verbatim from the board meeting held on 8 March. But before I get to that, Ms. Maury, when we started this debate and discussion this morning, we were at idem that we will deal with these commission matters on a friendly basis. Can I just ask you, why did you and Mrs. Dlamini, before you went to the board, discuss this matter with me?
So if you refer to the 6A being the annexure of the verbatim, and you actually referred to my utterances, what I uttered in there was the request for support. So Advocate Laba, the request for support is because the board had made the resolution that POSWA will not help staff with their statement.
My question is, Ms. Maury, and you make a very serious allegation of dishonesty against my colleagues, that they approach potential witnesses to provide statements in Word format so that it can be tweaked by them. Why didn't you discuss the matter with me before you took it up with the board? Or, alternatively, why didn't you report it to POSWA, who was the appointed legal representative of the PIC through which I must correspond with the board? Why didn't you approach POSWA and say to POSWA, please contact Libba and ask him what's going on?
So, can I respond, Commissioner? So, Advocate Laba.
No, address yourself.
Oh,
to
sorry,
us.
sorry, I forgot. Commissioners, if you refer to the verbatim, and you refer to the second part that is highlighted by red, being by Ms. Lindiwe Dlamini, she mentions the tweet, and that's in the third line. So I cannot respond to that because that was not a comment that was made by myself. The comment that I made was that staff had requested some form of legal support with their statement. So I've never uttered the words to the board that it was tweaked. If you read...
No, sorry to interrupt you there. I think you're being a bit semantic. You're sitting there, both of you have come to the board. This is a very serious allegation, so we have to deal with it. If it was not correct, you were in the same board meeting and you could have then said, we are not aware of that reasoning. You had an obligation. The two of you together had come to the board with a request. This was then, whether it was said by you or Ms. Dlamini, you were there and present and did not correct it. And therefore, if I was a board member, I would take it that you agreed with that. You were both there to make the same argument.
So the output through Commissioner, the outcome of the argument, we both were looking for legal support for staff. And in the discussion, and where if you refer to the verbatim, she says that it can be. So she's not saying that, she's like the fact that they're being asked for words, so she's not confirming that it's been tweaked. She says it can be because they've been asked in Word format. So the discussion in here, it was I represented information that I was privy to, she represented information which she was privy to, which I was not privy to. So I was not in any position to disagree with her because she was representing information that she was privy to. And my understanding is that she was also one of the people whose statement was requested to be in Word format. So just to clarify, I am not making an accusation on anything. So I've merely in my statement written the factual events that transpired regarding to this issue that was put before the commission. So I've not confirmed, I'm not privy to whether they've tweaked statements or not because I've never interacted with anybody that they had reviewed their statement in Word format.
But let's again look at what Dlamini says. She says, some of the things that employers are requested to do is to provide statements in word form that can be tweaked by, the investigators, And I think from a procedural point of view, that starts affecting the authenticity of that statement, which is one of the things we were worried about. Because at the end of the day, when that statement is being represented at the Commission, whose statement is it? Is it my statement, or is it the person who amended the statement, who provided the input in that statement? So those are the fundamental issues that we need to advise staff with. And then you come in. Chair, for me it is still being friends, but making sure people understand, because it now goes all the way to the most lowest level. And I think one of the executives said to me, the investigator said to me, write a statement like Victor's statement. That is your words. And it's nothing else, and I put it to you, Mrs. Moore, it's nothing else by agreeing with what Lindiwe Dlamini is saying to this board.
Commissioner, it's, in my view, is not agreeing, it's expressing what I have personal information to. It was expressed, and for me, it's a very difficult to answer what Ms. Dlamini said and deliberation, because Ms. Dlamini met with Advocate Laba, and Advocate Laba, at the point of meeting with Ms. Dlamini, had the verbatim. So I think maybe the best person to answer regarding Ms. Lindiwe's verbatim is Ms. Lindiwe's verbatim, because she is Ms. Lindiwe herself, because she had a meeting with Advocate Laba to discuss what this meant. For me, in that board meeting, was to say, I've been directly approached by staff in my capacity as acting CEO. I need to respond. I can't ignore it. If staff are requesting something, I have to provide it. And further, if you refer back to the communication which Advocate Laba provided to staff post having the verbatim, post having a meeting with Ms. Lindiwe Dlamini, he then writes to the staff to say that the statements are asked in word format to correct grammatical errors, mistakes, to supplement where necessary allegation, and to remove unnecessary allegations. I cannot confirm whether it's what the letter to staff was communicating. So I'm not privy to this information. So Ms. Dlamini is the best person to serve before, in my view, Ms. Dlamini is the best person to serve before this commission and explain that. I can only explain. And my keeping quiet was not necessarily saying I believe in what she was saying. She was representing to the board as the acting executive head of legal. She's the one that the team will go to. I had made an agreement with Advocate Laba from onset, considering that this commission, I'm a subject of this commission, is that I will stay away as much as possible from any staff members that are regarding this commission, just to make sure that I'm not perceived to be victimizing or influencing the work of the commission.
Did you know at the time that you were going to the meeting that Ms. Dlamini was going to raise this point?
So I didn't know that she was going to raise tweet, but what I had agreed with her is that, because we both got the request for legal support, it was like, okay, I will raise the issue for the board to reconsider their decision regarding providing legal support. So I didn't pre-plan with her what she will present. I just say, what we agreed is that we will highlight to the board regarding the idea that the board staff employees are requesting legal support. And Commissioner, if you actually refer to the annexures, I'll not give it, to the annexure, sorry, I'll give you the name for it. If you refer to annexure MMO2, if you refer to the timing that I received that email, was on the 13th of March 2019. And that email has been forwarded to me by Ms. Dlamini, because I then inquired from her to say, I've heard what Advocate Laba has presented to the Commission. Do you have proof that these statements are indeed being asked in Word format? Because now it's been attributed to myself and it's not a comment that I've made. Hence, she then forwarded to me this email from her team. And from our understanding, she's also one of the people who has asked to have a statement in Word format. So, through you, Commissioner, my words were regarding just asking for legal support, because the board had taken the resolution that POSWA will not help staff with the preparation of their statement.
Who sent this email really? Is it Lindiwe Dlamini or is it Boitumelo Leroke? The email that you've just referred to?
So Boitumelo sends it to Lindiwe, and then Lindiwe then on forwards it to myself.
And are you able to tell us who this executive was who you referred to? That one of the executives said to me, that's you now. Am I correct?
I'll have to remember. Can I come back and just refresh my memories?
As long as you don't forget.
No, I won't forget. I won't forget. I have to just remember which name it was.
It is just interesting to me that at the board meeting, Mrs. Dlamini did not mention that she had the similar request. But let me take you to the meeting I had with Mrs. Dlamini at your request. I expressed my deep concern about this statement to the board, attacking the integrity of my colleagues. And she immediately conceded that it was a wrong wording of the situation to the board, and I accepted that. And on the basis of that, I wrote the email which I requested the acting secretary to distribute to all officials of the PIC, in which I made it very clear that there is absolutely no objection of any employee taking legal advice before coming to the Commission. And that was the reason why, from the very next day, when everybody came into this Commission to testify, they were asked to state under oath that what they are presenting to this Commission is their own statement, and that nobody asked them to change or amend or supplement anything in their statement. Can you recall that?
What can she recall?
That after that incident at the board, the witnesses coming to the Commission stated that before they started testifying.
Well, will she know that?
Yes, she was here. And what's more, we will present evidence later that Ms. Mori at the PIC followed the Commission's sittings in her office. So if she can't answer it, it's fine, but that is my instruction.
So to say, do I read people's statement, people's testimony? Yes. To say when I had time, I would look at the Commission. Yes, I would look at them because I'm a subject to the Commission. Therefore, I would follow, and I knew that at some point I'll need to answer to the Commission. So I guess the answer to Advocate, do I follow the Commission? Yes, I have been following the Commission.
And did you hear when they are asked, is this your statement? And so on.
I heard him, and I think, it was on the 14th or something, where he started saying, if you even refer to a transcript, he then confirms from the 13th that is why you're starting to hear the employees being told this is their statement, them confirming that this is their statement. Through you, Commissioner, just one point. I can't discuss what Advocate Laba and Lindiwe discussed. I'm only privy to certain information that has been provided to me. And I think maybe exactly what transpired inside the meeting between Advocate Laba and Lindiwe, only Ms. Dlamini and Advocate Laba can answer. I can only discuss what was reported to me and the emails which I was privy to.
I accept that. Thank you, Mr. Commissioner. Now, if we can come back to the correspondence with the board. And you wouldn't know that, but I put it to you that at the request of Mr. POSWA, we had a meeting in Centurion on Wednesday, the 13th of March. At that meeting, we had wide-ranging discussions about the Commission and the requests of the board to certain matters, and we also discussed the verbatim of what happened at the board meeting on the 8th of March. As a result of that meeting, I sent him an email, and I referred to Annexure 7, Mr. Commissioner. You will see it is dated the same day, the 13th of March. It was sent at 9:07 in the evening, where I mentioned to him what happened at the board meeting and that it may be a transgression of the proclamation, it might be victimization, etc. That is in the, I'm not going to read it, it's in the annexure. Then on the same date, the 13th of March, Mr. Posma sends a letter to the board dealing with certain matters, and also in paragraph 8 he mentions what happened at the board meeting. And I think you will notice from your next annexure, that is annexure 8, it's an email from Mr. Posma. It is dated the same date. It was sent to the chairperson of the board, the deputy chairperson, Mrs. Zulu, and to yourself, and it was copied to the acting secretary. It was written at 4:04 midnight, attaching the letter, and also seemingly attaching my email I wrote to him. So just to correct you, there was never any correspondence directly between me and the PIC board regarding this incident. It was an email sent to me as agreed with the PIC to Mr. Posma.
Through Commissioner.
Do you have any comment to make
Yes,
on that?
through Commissioner. At no point did I ever say there was an agreement between Advocate Lover and the PIC regarding any allegations leveled against myself. Earlier on, through Commissioner, you asked me if I was privy of any such letter, and I highlighted that I was not privy to it. I'm just stating the facts that were disclosed to myself in my precautionary suspension letter. I think the board that took the resolution and decided that that shall be the terms that are written in my precautionary suspension letter, they're the best to explain and provide guidance to say, when they said allegations leveled against myself but Advocate Laba, what were those allegations? So I'm just giving background of information that I'm privy of. So I am not privy to what was that the board utilized to come to that conclusion.
Thank you. I just want the purpose of this question just to have clarity on that I never directly wrote to the board about this meeting. It was via Mr. Posma's office.
I guess my comment is noted because, like I said, I'm not privy to any of these communication.
At this stage in March 2019, when the Commission started its work, there was, and I just want to find out from you, do you know there was already a reluctance from employees to come to the Commission?
No one would have been providing me that information that there was a reluctance.
You didn't know about that?
But a reluctance of employees coming here.
Yeah.
No one interacted with me about the reluctance.
Nobody told you that there is a problem that employees were not keen to provide statements to the legal team or the forensic team of the Commission?
The most communication I had, Advocate Laba, is on the 6th of February. You called me into a meeting. You asked me...
No.
Sorry?
To us.
Oh, sorry. Apologies, Commissioner. On the 6th of February 2019, around about 10 o'clock, Advocate Laba asked to see me privately. Inside that private meeting, he then said to me, he's providing fatherly advice and is recommending that if I have a good relationship with the Minister of Finance, to approach the Minister of Finance and ask to be placed on special leave. I then highlighted to Advocate Laba that what would be the basis of me approaching the Minister and asking to be placed on special leave. Advocate Laba highlighted to me that there are various allegations that have come before him regarding my involvement. And I requested that can I be given those allegations, and therefore I'll take that into consideration. Advocate Laba highlighted to me at that meeting that he was just providing fatherly advice. I said it to him, I note his fatherly advice, and I will, until I've been put forth with allegations that deal directly, I will then assess that. So that was the last communication I had. So I can't recall anyone specifically coming to me and saying, staff are reluctant, staff don't feel comfortable, because I had had an agreement with Advocate Laba that I will stay away in all respects. And staying away is staying away with the witnesses. And any witness that might have come to my office would have been in them carrying out their duties. And therefore, I'll give an example. The then general manager of listed equities will come to my office because it's part and parcel of production. So asking, updating me. So no one has come to me directly and said, Matsapo, the witnesses are afraid to come because of you. Further, we only communicated to staff about the appointment of legal service between the 14th and the 15th. By the 13th, we hadn't appointed or communicated to staff, so let me correct. We had not communicated to staff that we have appointed legal support. So, which was for me strange that they're already experiencing reluctance.
I think the question was, did you know that there was this reluctance of people at the PIC to come to make statements and come to the Commission?
Through you, Chair. Through you, Commissioner, I wasn't aware. And I can't recall somebody coming to me and saying, Matsapo, people are reluctant to come to the Commission. As what I understood, everyone was a friend of the Commission, and everybody was even available, was sitting with Advocate Laba and his team on the second floor, because we had specifically even agreed with Advocate Laba that they will not sit anywhere near me, so that it's not even perceived that I have the ability to victimize. Even if you recall, Commissioner, even if you look at the witnesses that came before the 13th, most of them were either ex-employees or employees that have been suspended, they've been placed on suspension. If you look at the employees that subsequently came before the Commissioner, they may be to a certain extent implicated in victimization, but most of them have not. So I'm not sure, I can't recall of any moment where maybe someone specifically said to me, people are reluctant.
And just to clear this up, the question did not mention that they were reluctant because of you. I think Advocate Laba just said that they were reluctant to come.
So, Commissioner, I'm not, and you know, a lot has happened. I don't believe anyone came before me and actually said the employees are reluctant to come. All I know is that employees highlighted, and I'll give an example. The one employee who directly approached me was Ms. Constance. She said, I've already incurred expense on one statement that I need to prepare, and the Commission has asked me to prepare, I think 5 more, I can't recall it clearly how many. Is it not fair for the PIC to actually provide staff with legal support so that they can help review my statement? And she highlighted that because she wants it factually. And then that's when I said to her, I will approach the board to request them to consider providing legal support for staff to prepare their statement.
So I suppose, in your view, that reluctance might be as a result of people saying, we don't want to pay for legal costs for making statements for the Commission.
I would almost...
That's how I read you.
Yes. I would say that for like the one person who directly approached me, because she had already said she had already spent like 30,000 on one statement. And I can imagine the legal costs, and they were just carrying out their duties. Their statement, it was about the work they're doing to the PIC. It was nothing to do with their personal. And if I recall, it was not, this was a voluntary basis. So I wasn't aware of, I wasn't aware of any reluctance. And if there's a reluctance, I will imagine it's not reluctance to be interviewed. It could be reluctance to prepare a statement before this commission because of the legal cost. That could be that people would want their statement to be reviewed by some legal person.
And it will help, Ms. Moore, if you just answer the question. Because sometimes the question is just simple, but you carry on and in that way raising further questions to come.
Sorry, Commissioner.
You saw fit to divulge to the Commission the meeting I had with you, and where we agreed that it will be a private, off-the-record and confidential discussion. Why did you do that?
It's not about I saw fit. It's about that you're asking if there's any place that I was discussed where someone highlighted that there could be reluctance. So I was confirming of a meeting, and if I understand, I'm under oath here. So in being under oath, I'm supposed to tell the truth, nothing but the truth. So it was not I saw fit to position it in a certain way, but I was asked the question and I was responding to it.
See, this is exactly what I was referring to. You brought that out when it was really not necessary at all in answering your question. But it's done now. And I think Advocate Libbe is entitled to ask you why you did it.
Thank you. So let's then conclude this chapter of your statement. There was this meeting after the board meeting with Lindiwe Dlamini, where between the two of us, we sorted matters out. A communique was sent out to staff members, and as far as I'm concerned, that concluded that chapter. Have you any idea how many employees did make use of this law firm?
So specifically, we had, at the point I was still at the PIC, I have no idea, because specifically we had requested that we don't get told as management to protect them.
Because I must put it to you, and you don't have to answer, that members of the PIC who came to us to give statements told us that they will definitely not go to this law firm because they don't trust the law firm, and they expect that the law firm will tell the PIC, and especially you and Dlamini, about the statements and give them copies thereof. So I know you can't, but I just put it to you as a fact that that is what was told.
We don't expect you to answer if you don't want to. In fact, it's not a question for you to answer.
So, but can
if you do want to comment,
can I maybe recommend, because of the, we said it will remain private, I'd recommend the Commission to approach the law firm and find out if there's any staff members that have made use of them.
We will do that. When this commission started with its work in 2018, was there already a culture of fear and intimidation?
So maybe to respond, so you have climate surveys that way, and I think Mr. Polwane highlighted the climate surveys that had served before the PIC, so which had highlighted issues, and that's one, and there was also issues of communication and stuff. So there was a perception from staff, and we were in the process of addressing them.
And that perception was one of fear and victimization.
So, without having the survey there, if one of the, I remember it was, is it victimization? I'm not sure the word, but it was one of the highlighting that there's some culture in terms of people not being able to express themselves.
People were scared to complete an online questionnaire at the time. There were a very low percentage of employees responding online to the questionnaire.
Do you know about that?
The climate survey, yes, because then we had to find other mode that they can write, yes.
So do you agree that there was a very low percentage outcome of employees responding online?
Was there a low percentage, yes, but the overall percentage was about 50, if I recall clearly.
That was after intervention to ask employees to put hard copies in a box, which resulted in a bit of an increase in respondents.
Sorry, Commissioner, can I maybe request what's the question?
The question is, the only reason for the increase was that there was intervention by HR to say you don't have to do it online, but you can put it in a box.
Confirm?
You know that?
Yes.
Okay.
And that didn't even take it to 30 or 40%. What happened is, what took it to 50% is, it was decided to add the neutrals to the positives. That Mr. Pulwani conceded in his evidence.
Sorry, the 50%, to the three commissioners, just to get a clarification of the question, is the 50% about the participation or is it about the outcome?
The participation.
Three commissioners, I'm a bit confused, just clarification. If the participation is 50, how would the neutral, just maybe clarification, what does it mean?
It's difficult. I understand it's difficult for you to deal with it, but we have now discovered this climate survey thing. It is with Mr. Pulwani. It's made available, and it will serve before the Commission. Just to end this part, whether it's real or a perception, do I understand you to concede that there was this fear and perception of victimization among staff members in 2018?
There's a report. Whether it's not about my beliefs through Commission, it's about what the outcome of that report indicated. So can I not express a view, because I'm not privy of the people who completed it. It's just to say there's a report that's been put in place, and if I recall, Mr. Pulwani in his statement provided some clarification regarding it. So was the climate survey prepared? Yes. Was victimization and communication one of the issues? There's a couple of outcomes that came. Yes, there's outcomes that came out from the climate survey.
Thank you. You can then proceed with paragraph 4 of your statement.
Sorry,
Can I fully? I've got some question.
I've just got one.
Okay.
Thanks. Perhaps if we could just go to the question you've raised in your 3.2, if I remember, that your suspension was mainly based on the allegations of victimization. Is that correct? And interference in the work of the Commission.
So that is what my suspension letter writes.
Then this question that I've got here, which is a dismissal final written warning that says breach of your fiduciary duties as a director, that you're required to provide, to promote and serve the PIC's interests diligently and faithfully, gross negligence in that you signed the settlement memo before the PMC1 had approved the IO transaction and acted as chair of the meeting committee that sought to regularize an irregular process, and a breach of your contract of employment in that, and it goes on to look at some of the breaches there. So it is not just the question of the investigation, interfering in the investigation, it is also the AO transaction, is that correct?
Through Commissioner, and I apologize, I'm going to go the long-winded again. So I can confirm what my precautionary suspension letter wrote. Subsequent to that, I went and requested Advocate Laba to assist me and obtain the internal audit reports in preparation from this inquiry, my appearance to this commission. I can tell you that based on the first draft of the internal audit report and the final draft that what was written, based on what you're reading out, there's been changes regarding the statement that I've given. And I can provide you because I've provided copies. Therefore, I can only assume that post the finalization of the internal audit report, especially as it relates to my section of what I provided, could actually be what those charges relate to. Because when I looked at the two reports, that section of my report has been adjusted, specifically my part, has been adjusted to suggest those charges. So as it sits today, I've not been served with charges, but if I look at the final draft of the internal audit report and compare it to the draft that was issued in December, I would say the changes that have been between those two documents are leading to those charges.
That's the internal audit report, the finalization of the internal audit report into the AO transaction and the PMC role, what happened, what didn't happen.
Yes, Commissioner.
Okay, two questions from me. Let's go to paragraph 318, the last sentence there. The chairperson indicated that the board had a legal opinion. Was that the letter from POSWA or this was a different document?
So, Commissioner, I was not privy to it. They were just telling me that they've got a legal opinion, and I didn't ask to be provided that legal opinion. So I'm not sure what
You're
legal
not
opinion.
sure whether it's that letter or something else?
Yes, Commissioner.
All right, okay.
Sorry, can I just ask in relation to that, colleague, why would you not have asked for what the legal opinion was?
Already highlighted in that, Commissioner, when I tried to inquire it was in my process of inquiring what is resulting in me being placed on precautionary suspension. Then they just said to me, the chair said, we've already got a legal opinion. The purpose of me being called into that board meeting so that they can tell me face to face and that it is still subject to the minister's approval and I don't just see it in a letter. So I didn't have and at that time, and you can put in my position, it was like, okay, is this what's happening? Fine. And hence why later on when I officially got my precautionary suspension letter, when I found the words exactly was written to that, I then inquired from Advocate Laba to say, what are those allegations so I can respond to?
Okay, the next question from me is on the MS Word and the PDF document that Ms. Dlamini talked about. I mean, I'm just trying to understand if we have terms of reference and there's a note being given out and the legal team wants to make sure that whatever is written is within the terms and you don't implicate other people, what is wrong in asking a Word document? I mean, because in the end, isn't it that the person signing that statement must read it and say, I'm happy with that statement? Can you explain what could be the problem there?
So I can only speculate. I cannot confirm that people were uncomfortable. Exactly to the reason what happened, I think, like you can ask Ms. Boitumelo and Ms. Lamini can respond. So if you look at my statement, I didn't experience my statement being asked for in Word format. It was automatically sent in PDF. So I can't really confirm, but like I've highlighted, it was just about employees asking for legal assistance.
Okay, all right, thank you.
Yes, Advocate Laba, can the witness now proceed?
The witness can proceed with paragraph 4, Mr. Commissioner.
Paragraph 4, section 4, which relates to allegations and insinuation of victimization. At the outset, I wish to point out that whilst a number of employees who appeared before the Commission made allegations and/or insinuations that I have victimized them, almost all of them have not referred to any specific incident or event to support what, in my view, are overly broad and unsubstantiated allegations. I further wish to highlight that since becoming the CFO, majority of the finance team remains in the employ of the PIC and in my team. In fact, some of the team members who had resigned or moved to other departments have rejoined the finance team.
So can I just refer you to Mr. Ntwani's testimony here, where he refers specifically to reducing his performance score by yourself, a lack of communications or meetings with him, although he was a direct report, and that he was suspended on trumped-up charges. Those are quite specific.
Okay.
You may have a different view on them, but those are specific.
Through Commissioner, later on I do deal with Mr. Ntwani, if maybe I can then revert to the question at the end. It is not uncommon for any person who occupies the position of a CFO of an organization to be perceived by some sections of the organization to be victimizing them, due to the nature of the role that a CFO plays in an organization. Decisions relating to finances that are taken in the ordinary course of business in the best interest of an organization are not necessarily always in line or in favor with all the employees of the organization.
Sorry, I just want to ask you about that, because that looks like something saying that it's an inevitable outcome of CFO. I have no, very limited experience of a CFO being charged with victimization or system in other organizations. I think that depends on the structure, depends on HR, but this is a very specific question. And to say that the role of the CFO is a tough one, yes, it doesn't normally result in an atmosphere or environment of fear and victimization and as you just acknowledged in the survey. All of that, it's sort of a hazard of the job. Yes, you have a hazard of the job that people will disagree, but not necessarily. It's not inevitable. This represents it that the inevitable outcome of CFO role in an organization is strongly victimization what is happening to them, work performance, their own positions and roles. That's not normally a CFO, it could be HR if that perception, but for CFO to have that perception presented as if that's, part of the course of being a CFO, I'm surprised at that.
So through Commission, when I get to the section of individuals that have appeared before the Commission and I deal with circumstances, I think that statement will become clearer to what I mean, and I will detail, which I detail incidences that result. And I think specifically with Mr. Ntwani, when I get to his section, I'll highlight where there was disagreements that could have resulted in his feelings. When I get to that section, I'll deal more directly with it. So 4.3, allegations relating to James Noble investigation. I had the opportunity to go through the statement of Mr. Kulwani as well as transcript of his statement before the Commission on 27th and 28th May 2019 relating to allegations of victimization and or intimidation arising out of James Noble investigation. I do not think that there are any specific issues that the Commission raised which require my input in my capacity as a CFO. Should the Commission request that I address any specific allegation, I'm more than willing to prepare a supplementary statement in relation thereto. I do, however, wish to address one specific submission made by both Mr. Siniya Maniseva and Ms. Myogazi Meni, i.e. that the granting of super administrator privileges is good governance and or justifiable.
that the whole process was a whistleblowing process. And between you and Dr. Majila and Mr. Polwane, I think I stand under correction. You basically took the position and tried to investigate the whole thing, and they felt that the biggest point was that you were not supposed to do that because it was a whistleblowing exercise, and this thing was supposed to be investigated by an independent party. Like, how do you answer to what they said is one of the biggest issues that they had a problem with?
Through you, Commissioner, in addressing that question, please allow me, I'm going to provide background. So, and the first, I think, important date is leading to the board meeting of 15th of September. And some of my dates might not be, might not be correct, and I'll come back and clarify them. The board meeting of 15th September, which was the ideal to deal with the MST, which allegations that came in from James Smith of MST. As part and parcel of that, one of the board resolution was that we need to look
the other people, and that they were not even sure about the procurement of those services, which is, the next question I wanted to ask you, that procuring those people and this thing snowballing out of control, how do you answer to such questions that they put forward? And
on an urgent matter. So what was concerning us is it looked like there was a breach into our systems. And the implication, if indeed there was a breach into our systems, it's very big. Considering how much information flows, and we do not have a sense how big the breach is, because whether you call him PIC Shield, PICI, and I refer to James Nogu, we didn't know the vulnerability. So Naledi was appointed initially with BCX. So BCX had subcontracted to Naledi to try and ascertain the weaknesses and to figure out exactly what is happening, where's the system breach. And then I think Ms. Menya and Mr. Maisela spoke about SensePost. And my understanding is SensePost is ethical hackers. So what they do is they try to see where your weakness is. So they try to hack your system. Further to just comment, so now I think on an annual basis, IT is actually conducting these vulnerability and penetration tests to test the vulnerability of our systems.
You raised this question of being very security conscious. Would you... I mean, I was surprised. It would be a question why you felt comfortable raising the question of blocking emails with Ms. Menya when she's with somebody you don't even know, and openly speaking about it. Yes, it might have been at your workshop, but you didn't know the person if it's a confidential matter.
So if I recall, and I can't recall clearly, we'd already started sitting in the meeting, because if you recall, Ms. Menya highlights this was during lunch, where the discussion took place regarding, and if memory serves me correctly, and I'll double check, is that I'd already met the guy. So it's not, I'd already seen him, but not formally. So it's not about the breach in security. And the fact that Ms. Menya, so we actually pulled Ms. Menya aside, and she actually, if memory serves me clearly, is that she then called that he must come, Simpiwe must come because he's security. So that discussion was about the reason why is we're not aware that the attachment that was being attached to the email, does it contain viruses? What does it contain? Because we were not privy to that. We were not fully aware. Hence, we then said, contain it. So in case, in the event that it's got viruses, it's not spreading into the systems and putting further weaknesses into our system. Because in the appreciation that a lot of the listed is actually sitting on our servers.
Okay, just you talked about lunch, and I think it's about that time. The question,
just a follow-up on this issue is that you mentioned that there were two processes. So there was the one process about the allegations, and there was a process about the safety of the systems, all right? So on the latter part, don't you think that this thing went beyond the critical point of safeguarding the IT, and then it went to the effect of let's find out who James Nogu is, then snowballed into Mr. Maisela laying criminal charges or cooperating in criminal charges? So don't you think that latter part actually snowballed out of proportion?
Can I maybe ask clarification? Are you saying it snowballed in that at some point after the test of systems it should have been stopped, or that the whole process?
Yes, because what was said was, the minute you try to find out who James Nogu is, you are impacting whistleblowing as a first thing. You are no longer even in the trying to safeguard the PIC's systems. And even the sense post, or the so-called 6 people monitored and the emails monitored, led to some people getting fired and all that. So don't you think, besides the internal process, which was the first one, and then the second process went beyond what was supposed to be? I hope I'm clearer now.
I hope my answer, I think I'm getting through you, Commissioner.
Or Judge, can you help me out?
I'm going to try. On discussions, a lot of discussion of the progress, I was not necessarily privy to in the meetings. And if I've looked at some of what the presentation has been here and what I was aware of, it was actually Mr. Simpiwe, I think, who advised the then CEO of a process, I think they call it Section 206 or something like that, to pursue it, to figure out who this person is and what information they have. You know, in hindsight, what now your question is now, it's the perception afterwards to say, what does it look like? And now it's in hindsight that we can have discussion. So and at some point, if I recall, that investigation was ceased to say, we put the peg here, no more investigation and stuff. So how the disciplinaries, the people whose emails were actually requested. For me, it's part of an investigation if you're trying to investigate something and trying to ascertain certain information. So I don't want to assume that the first intent was malicious or to victimize. It's about the third process, because the same process is used for the commission, that they are accessing employees' email, then I don't think the sense of that is to victimize. And it's difficult for me to provide the intention, but I can only communicate to you that when we went before the board, this is the discussions we had.
But then the process that was supposed to safeguard the PIC systems actually ended up into a lot of people getting fired, because of that, and they contend that it was a whistleblowing process. Any comment?
Means what was supposed to be an investigation into the system and how it was breached and so forth, it went on to an investigation of who is this James Nogu instead, and people got fired.
Through Commissioner, maybe I would talk about, and apologies if I'm going long-winded, is I think the 3 employees that were directly impacted by the James Nogu, which is the idea before this group. And when I listened to the transcript, you were clustering them into groups. Now, when I look at Ms. Menye and Mr. Simpiwe, and I specifically address in my statement regarding the good governance in terms of giving super user rights and my personal views of what that meant. It was good governance and stuff. So when I read my statement, then it will be clear on my views of it. So it's those 2, and like I highlighted, most of the disciplinaries, I guess, as much as people appeared for, they happened during the period I was also on maternity leave. So I'm privy to certain reports. I'm not privy to all the discussions that transpired. So I can give Ms. Matebula's view. If I understand clearly, it was the charges related to leaking information to somebody else. And it's a governance. So those things are breach of policies and stuff. So I don't know if that answers, but what I'm trying to say what happened to it. So I'm not sure at what point that you'd say stop, because some of these things came out during the process.
break now for lunch until 2:15.